down and upset. So I'm sure the chair can find some technical reason why my resolution to protect free speech rights on the public's airwaves may not be in order. So all we were trying to do is offer an amendment that had been offered up in 2007 and approved by over 300 members of this House when it was allowed to be considered and voted upon. It was approved by over 300 members to protect the free speech rights of broadcasters, the citizens of this country as well. And instead, what we have now operating, I believe, affects the very rights of this House collectively, affects its dignity and integrity of its proceedings, and affects the rights of its members as described under Rule 9 individually in their representative capacity. That is why I brought this privileged resolution to the floor, because I believe as a citizen of this country and a member of this great institution that our rights have been diminished and that indeed the integrity of this very House is on the line. And in fact, when you go to the Speaker's website, at least I think it's still up, she pledged an open debate and an opportunity for members of Congress to be able to come to the floor and offer amendments, much like the chairwoman has done over time, and relishes that, as I do. It's part of what we do here, or what we were sent to do here. It's pretty hard to offer up alternatives to spending bills, to reduce deficits, to put ideas into law, when the Speaker's Rules Committee acts and shuts down our very opportunity to even bring amendment up for debate. Whether it passes or not will be up to the collective votes of this body. But we know that if we can never bring them up for debate, there will never be a vote. Now, maybe that's convenient to those who don't like to vote on difficult issues or stand up for the free speech rights of broadcasters, whether they be religious broadcasters or those on the right or the left on talk radio, which is what my amendment would have sought to protect in the future. But I really believe that Rule 9 is intended to allow members to raise questions affecting the rights of the House collectively, to discuss its safety, and that's not an issue here, but its dignity is, its integrity of its proceedings are, those rights. These are fundamental to each of us, regardless of the label behind our name that designates our party. This is the one time we've had in this institution to come forward with our ideas on how to control the bureaucracy, to offer an amendment that controls it. It's the only time me as an individual has that opportunity in the appropriations process, because I'm not a member of that committee, to represent my constituents. That's why I believe under Rule 9, my representative capacity is diminished, and that of many other members in this chamber, and many who are watching right now. The public needs to understand this as well, that something's changed here, and it's not for the good. And I think it reflects badly on our proceedings. And I think it injures the integrity of this institution, let alone its dignity. And that's why I make this parliamentary argument, that under Rule 9, members, it talks about collectively affecting the House. Tell me when members of the minority or majority come before the Rules Committee and seek, well, first of all, have to even go to the Rules Committee. That didn't used to occur on appropriations bills, did it? Didn't used to occur. Only rarely. Maybe once or twice in a year. And otherwise, I appreciate the gentlelady's counsel, and I will attempt to do that. I was trying to do that here, and certainly I'm arguing in favor of the rules of this House being observed. That's why I argue about the integrity of its proceedings. In my view, proceedings have been shattered. Members of both parties are denied the opportunity, as our predecessors were allowed to have, to come to this floor and offer up amendments during the appropriations process. So I think my privileged resolution should be made in order, because I think my rights have been affected, and not in a good way. The rights of other members are affected. I had more than one person on my amendment. And so individually, our representative capacity has been diminished. The voices I'm trying to represent are not allowed to be considered if I can't get my privileged resolution to be considered. All it did was ask for a vote on my amendment, that it be made in order so we could vote on it on the rule, which, oh, by the way, at this point, the way this process has been conducted, not only has the rule been passed, but also the bill's been passed. So it's kind of ironic. Now we'd have this argument about whether my privilege resolution was in order, which would have allowed me to, if had it been secured, it would have allowed me to have some additional representative capacity and be able to have a vote on the amendment, or a vote on whether I could offer the amendment. I guess that's what would have occurred. So I posit this point, that under Rule 9, we are allowed to raise questions about issues that affect the rights of the House collectively. I can't think of something that affects the House more collectively than our inability to offer amendments. And so I think our integrity is at issue here. These proceedings, I think Americans have come to understand bills are rammed through here without the opportunity to be read. We got a 1,026-page bill in the Energy and Commerce Committee that I can't imagine anybody's read yet. So, Madam Speaker, I'll conclude that I hope you'll rule in my favor, because I know in your heart of hearts you're a woman who believes in fairness, and you believe in the integrity of these proceedings, and you believe firmly and fervently in protecting the rights of members, both individually and collectively, and that you in no way would want to diminish the capacity for yourself when you're not in the chair, for members of this body, and for members who will follow us. So I plead with you to do the right thing and allow a vote on my privilege resolution, and I return the balance of my time.
The gentleman yields back his time. The chair is prepared to rule. In evaluating the resolution offered by the gentleman from Oregon under the standards of Rule 9, the chair must be mindful of a fundamental principle illuminated by annotations of precedent in Section 706 of the House Rules and Manual. The basic principle is that a question of privileges of the House may not be invoked to prescribe a special order of business for the House. The chair finds that the resolution offered by the gentleman from Oregon, by proposing directly to amend House Resolution 644, prescribes a special order of business. Under a long and well-settled line of precedent presently culminating in the ruling of July 9, 2009, such a resolution cannot qualify as a question of the privileges of the House. The chair therefore holds that the resolution is not privileged under Rule 9 for consideration ahead of other business. Instead, the resolution may be submitted through the hopper in the regular course of business. Gentleman from Oregon.
Madam Chair, I regretfully appeal the ruling of the chair.
Madam Speaker.
The question is, shall the decision of the chair stand as the judgment of the House?
Madam Speaker, I move to table the appeal of the ruling of the chair.
For what purposes, gentleman from Massachusetts?
I move to table the appeal of the ruling of the chair.
The question is on the motion to table. Those in favor, please say aye.
Aye.
Those opposed, say no. Opinion of the chair, the ayes have it.
Madam Speaker,
from Oregon.
Since a motion to table gags any opportunity to debate, then I ask for the yeas and nays.
The yeas and nays are requested. Those favoring a vote by the yeas and nays will rise. A sufficient number having risen, the yeas and nays are ordered. Members will record their votes by electronic service. Pursuant to Clause 8 and Clause 9 of Rule 20, the 15-minute vote on the motion that the appeal be laid on the table will be followed by 5-minute votes on ordering the previous question on House Resolution 653 and adopting House Resolution 653.